I am a first-year JD student in Duke Law, and I'm here today with Cindy, another one now JD student in Duke Law, and Celia, our project leader, and DJ, our supervising attorney and director of Pro Bono project. So we're here to present you guys with some of the advanced care planning documents that maybe you can utilize and may help you. Just for disclaiming, we're only able to answer general questions, and the information provided by this presentation should not be construed as legal advice. We sincerely recommend anyone who wants to file any of the documents to ask for an attorney to help. So today we're going to cover 3 of the planning documents, 2 of the healthcare ones, and 1 finance and personal affair one. The documents today are only limited to North Carolina law, so state law may differ for other states. If you are in other states, we encourage you to speak with an attorney regarding the specific law. And those documents are only legally valid when you are alive. And they're different from a will, which is a separate process and will not be covered today. So generally, why do we need planning documents? So those documents are important for everyone to just start with. Without planning document, your important decisions may be made by people that don't understand your need or value most. So those documents are here to ensure you got to pick the trustworthy person to help carry out your wishes when you personally can't. And you can certainly avoid a lot of troubles, uncertainties, and other time-consuming processes by just doing those documents. There are 2 general key steps for each of those documents. First, you need to choose your trusted agents to carry out your wishes. And second, you will give authority and instructions to your agents via those documents. And remember that whichever the document it is, you can always set limitations on what your agents can do and cannot do. So some general advice on choosing your agents. You can choose the same or different agents for making different medical or financial decisions. And one important fact to remember that the agents are always here to deliver what you want. That means they cannot just make your decisions based on what they think would be best for you. They have to think from your perspective, and they don't control you. That being said, some of the important characteristics of agents, including that it is a trustworthy person and he or she can understand your value and goals well so that they can deliver your wish. And then by saying that they may have a long-standing and close relationship with you, and you must be comfortable with them making sensitive and difficult decisions regarding end-of-life care. And they should be able to navigate your family dynamics, have the experience and capacity to handle the roles, and ideally they live close, so when things happen, they can always respond to their duty in a timely manner. For example, some of the agents you may choose is your spouse, adult children, or other family members, and you can even choose your friends if they're trustworthy. The first document I'm going to introduce today is a healthcare power of attorney document, also known as HCPOA. So this is a document that allows you to choose an agent to make medical decisions for you. They only comes in effect when you become incapable to make those decisions. And as soon as you become capable again, like conscious again, those power of making decisions will come back to you. So when will the HCPOA comes into effect? That will be decided by a physician of your choice. The physician will only determine whether you are in the incapacity status for the HCPOA to come into effect. This physician can either be a physician you specifically named in the HCPOA document or your attending physician if it's stated so. So always remember that they are only here to determine your incapacity. They don't make any medical decisions for you because that's the job of your agents. And when thinking about which physician to decide, there are advantages and disadvantages of the 2 choices. If you want a physician you specifically name, they may have a clearer understanding of your conditions and your will. But if you want to be in a location that this physician is not at, it may be a little bit difficult to reach the physician. So we would recommend choosing the attending physician just for convenience purposes. So what does this document cover? Like what kind of powers you can give to your agent through this document? basically a quick answer for that is any major or minor medical decisions you could have made for yourself, you can give it as a power to your agent. That includes signing or out of healthcare facilities, consent to treatments, review or access to medical records. That is an important one because to make medical decisions for you, your agents would most have to access to your medical records. So be comfortable with those specific person to access your medical records is also an important criteria while choosing your agents. Withholding or withdrawal of life-prolonging measures is also another power that we will address later. Organ donation, disposition of remains, and autopsy. Again, always remember that you can set limitations in this document to your agent. Those limitations can be as extensive as you want, as is specified here in this simple document. I do want to emphasize on the power of withdrawing and withholding life-prolonging measures. So a life-prolonging measure is any care that postpones death by sustaining, restoring, or supplanting a vital function. For example, something would be something like breathing machines, kidney dialysis, antibiotics, and artificial nutrition and hydration. Always remember that they don't include any pain medication. So pain medication and comfort care is something you will always get access to. And withdrawal of or withholding of those measures are only allowed in specific extreme situations. That means if you have the possibility of recovering, those measures would not be withdrawn. I do want to emphasize on artificial nutrition and hydration. This will be withheld or withdrawn with a blanket authorization for withdrawing life-prolonging measures. And you can address this separately in HCPOA to put it out as like just an exemption of the agent's authority because how special it is. But in making those decisions, I would recommend to always discuss with the physicians while you are able to make that decision yourself. Because some of those measures, including artificial nutrition and hydration, could be harmful and bringing more problem to you than benefits. And you can always change it whenever you want. If you don't file an HCPOA, there's still a long list of people who can be authorized to make medical decisions for you. Here is the list, but again, they may not be in a best position to make those decisions for you, and you may want to choose someone else, or you may want to adjust like just the sequences. So I would think HCPOA is a better choice. The second document I will address today is another healthcare document. It's the Living Will, also known as the Advance Directive for Natural Death in North Carolina. A living will is different from a will in that it is only effective when during your lifetime, versus a will be coming to effective when death. So the function of living will. This is for people who wish to withdraw life-prolonging measures in at least some of the situations. That being said, if you are sure that you want all the measures, you don't need to file a living will. It's only when you do think that you want to withdraw some of the measures. So a living will help you state your wishes regarding the use or removal of those life-prolonging measures. And again, you will always receive comfort care and pain medications because that is not included in the life-prolonging measures category. You may think that your decision in the living will specified may have a conflict with your agent's choice in HCPOA. That could happen, but you have the power to pick which one overrules the other, so which one to have the final words on saying. We would recommend drafting a living will with the healthcare power of attorney so that if you are certain that you do not want life-prolonging measure in some of the circumstances, you can always specify in the living will, like by saying, okay, I want to ensure my healthcare power of attorney doesn't overrule my living will, by putting living will as a shall document versus a may document. So my life-prolonging measures shall always be withdrawn under those circumstances. A living will only be applied in one or more of the following three situations. You can choose which one or more for your circumstances. Just as a summary, those situations are: one, when you have end-stage diseases and may not live much longer. Second, when you enter into a coma and a doctor says it is unlikely you will wake up. Or you have something like advanced Alzheimer's, that is advanced dementia, and it's unlikely that you will recover. And again, because of the special circumstance of artificial nutrition and hydration, you can make a separate decision for them in the living will. So even though you specify that you don't want any life-prolonging measures in, let's say, the first situation, you can still say that I do want to receive both or one of artificial nutrition or hydration in this situation. So if you don't file a living will, there's still some law-defined situations where the life-prolonging measures can be withdrawn, but they need to go through like a lot of confirmations by your physicians and your agents, and that could be troublesome. And one important factor to remember is that the law-defined situations don't include advanced dementia. So if that's your situation, if you want to withdraw LPM in this situation, the only choice you have is to file a living will. Some of other documents you may access or be introduced to are 5 wishes, medical order for scope of treatment, and the DNR. We're not going to cover them today because most of them are medical orders you can discuss with your physicians, and they will be in a better position to explain them. And we'll hand it to Cindy.
So hi everyone, I'm Cindy, and now I'm going to talk about the legal requirements for healthcare power of attorney and living will. So these requirements are set out in the statutes. First, you and the agent must be at least 18 years old. You must sign the document in front of 2 witnesses, and each must be at least 18 years old. They cannot be the healthcare providers, their employees, and employees of your nursing home or adult care home. They also cannot be related by blood or marriage or have the potential to inherit. You can think of them as random strangers or friends, but if they are provided in the will, they cannot be the witness. The documents also need to be signed in the presence of a notary. The notary can be employed by the health provider, and most hospitals have the notary available to execute healthcare documents. Most, however, will not notarize a financial power of attorney. You will also need to go through an initial in certain parts of the documents. You can't do this without the witnesses and notary being present. It is to make sure you can take all the time you need to complete the document to reflect your wishes. And the final, you should give a copy of the healthcare power of attorney and living will to your doctor and hospital. This is important to have that on record. So if the document is not found, they can access it through the medical chart. And last, you can give a copy of a document to the agent or let them know where to find it. And a copy serves as well as the original document. The agent shouldn't be surprised by a document, and when you select the agent, you may consider how far they live from you. They may live within like 50-mile drive if possible, because the further they live, the more time they would take to come to like execute the will. And you may talk to them about that beforehand, like if certain numbers call, make sure they will pick up the phone. The healthcare power of attorney or living will can both be revoked as long as you are able to make healthcare decisions. You can revoke it in a number of ways, and it's meant to be as easy as possible. You can do this by writing, by executing a new document, by communicating revocation to healthcare providers and agents. If a power of attorney is not registered, you can just tear them up with an intent to revoke. It's true that some clients will execute and revoke one or more of these documents several times when their situations change. As we prepare the documents for you, we would ask you some pieces of information, including your goals, the name of the agents, their contact information, the most important of that being their telephone number so that they can be reached. Another question is which doctor will determine when house care power of attorney kicks in, so that it could be either your particular doctor or you want to allow the attending physician to make that call. And then are there any limits on the agent's authority? Another area of information is just generally what are your wishes about life prolonging measures? Maybe you have like different preferences for different situations. This document, Durable Power of Attorney, that deals with everything other than healthcare decisions, financial businesses, including financial businesses and personal issues. This means the agent has power to act on your behalf. Most commonly, this means signing a paper, access the bank or other accounts, paying the bill, etc. You do a power of attorney, so someone can act when you are incapacitated. The power of attorney by default is enforced immediately after it's executed. We say live when signed. Some people have concerns about that, and the power of attorney can be set to come into effect upon the occurrence of a certain event, typically incapacity. This is called a springing power of attorney. We recommend against this arrangement, and the healthcare planning project forms do not include option for springing powers. We call it durable power of attorney because it continues to be effective if a principal becomes incapacitated. There are a number of duties not waivable on the agent, and they are listed here. First, the agent must act according to your reasonable expectations to the extent they actually know. And otherwise, if they don't know, they must act in your best interest. Second, they need to act in good faith. And third, they need to act only within the scope of the authority granted in the power of attorney. This document is different from the other two because it is involving money and property. It makes people more concerned about the agents they would choose. And there are a number of duties that are waivable under the statute, but these duties are not waived in our power of attorney forms, such as they must act not to conflict your interest, and they must act with reasonable care, keep a record of all the receipts, cooperate with the healthcare agent, etc. And the agent has the power to buy and sell and move things around, but they need to be consistent with what you plan for. And basically, you need to pick someone that you trust and who is very organized. This is a list of general authorities that you give to the agent in the power of attorney. It covers real property, retirement plans, business insurance, bank accounts, and a lot and anything else. For instance, real property means the agent can lease or sell your home. Tangible personal property is like your car. Taxes means the agent can file a tax return for you. Banks and other financial institutions are your savings and checkings. There's no harm to include all of them. The forms allow you to eliminate those that seem not apply. Specific authorities are hot powers because they are more sensitive powers to choose, has the potential for self-dealing or abuse. It includes making a gift of your property. It also includes changing survivorship. Which means that if you and others jointly own properties, one dies, the other receives the property. The third means to change who gets money from your life insurance policy or a retirement account when you die. If you designate someone to receive the benefits from your life insurance policy or retirement account, and the beneficiary is outside the will, the agent can theoretically change the receiver, even if the agent cannot change your will. And the last one is to allow the other person to exercise the authority that the power of attorney grants. All of these authorities by default are turned off. You need to turn each one on one by one, like affirmatively. There are several restrictions on exercising specific authorities in the statute. First, the agent will determine the authority is something that you want them to do. If a noun, they will exercise based on your best interests. In general, the agent cannot exercise specific authorities in favor of the agent or someone the agent owns a support obligation, which means like the agent's child, unless the power of attorney says so. This is a special limitation that we would add onto your power of attorney. A durable power of attorney must be signed by the client in front of the notary. There's no witness requirement in this document, so this is different from the healthcare documents. After the power of attorney is executed, you can give a copy to the agent, but you should remember that the document is live when signed. So if you give it to the agent can use it. You should let the agent know when, if they want to be used, or how to use it if you're going to give them a copy. Alternatively, you can just let the agent know where to find the power of attorney when you need it. Note that a copy of the power of attorney can be used. So if you give that a copy, it's usable. The original power of attorney can be recorded at the register of these. But this is not a requirement, except for use in real estate transaction. Recording is done by sending or bringing the document to the register of these for a small fee, which is $26. If you don't register right away, you can do that later. The office of the register of these will stamp the document at the top of the page. A copy will be made and will be publicly available in the book at the office. Additionally, an electronic copy of the document will be available online. The statute sets forth when a power of attorney will be terminated or revoked. First, it's important to know that it's no longer valid after death. Upon the death, power of attorney is revoked. You will immediately take control of the deposition of your estate or assets. Second, the power of attorney will terminate when you revoke. It should be revoked in writing and in a new power of attorney as well. The power of attorney can terminate on a date specified or its purpose is accomplished, such as, for example, a real estate transaction that the power of attorney is focused on is complete. Also, it terminates if the agent dies, becomes incapacitated, or resigns, and there's no successor agent. And finally, a power of attorney can be terminated by a guardian appointed for you, and the guardian would be entitled to terminate power of attorney. Yeah, I think that's all for our presentation. Thank you so much for listening. Now we open our floor to any questions you have.